right from the very first second. The judge's tone tells you everything you need to know. Calm, controlled, but undeniably authoritative. This is not small talk. This is a legal pressure cooker. And listen closely when the judge says the name Janetta Pugh. There's recognition there. Familiarity. That moment alone tells us this isn't her first appearance in this courtroom. And judges never forget repeat players. Quick legal insight here.
Good morning. Are you Janetta Pugh?
I'm the beneficiary of the estate.
You're the what?
I'm the beneficiary of the estate.
You're the beneficiary of what estate? Answer my questions, please, ma'am. I'm just trying to understand.
Beneficiary of the estate.
Okay. What's the announcement?
Judge, it's my understanding that Ms. Pugh and her family has retained an attorney on this matter. I don't know if you remember, Judge.
When multiple attorneys withdraw from the same case, that's never a good sign. It usually means communication has completely broken down, or the client refuses to cooperate. Judges see this as instability, and in a courtroom, instability equals risk. You can almost feel the judge's concern growing as the pattern becomes clear. Interview 3.
And we want the trial docket. She hired a new attorney at that point. Mr. Norwood, who was on the case for a while and then withdrew. And once recently, when the case came back to me, I visited her and was told that they did retain another attorney. I was given the name of Christopher Wiley this morning, but I have not heard from him. And my understanding is that at this point still hasn't filed anything with the court.
Okay.
But I've been told that that's who's supposed to be taking over the case.
Okay.
For the record, I recognize Ms. Pugh. She's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find.
Hold on, did you catch that? The so-called new attorney doesn't even exist in the state bar registry. That's a huge red flag. Either someone is intentionally stalling the case, or the defendant has been seriously misled. Either way, the judge's patience is wearing thin, and once that patience is gone, consequences come fast.
As a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Pugh's behalf.
All right. So, Ms. Pugh, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact the court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that the first duty is to the state and will be considered conflict of interest.
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, two things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself, or are you going to let Mr. Lewis represent you, or are you going to hire someone?
Objection, Your Honor. Respectfully, is this
moment right here? Classic sovereign citizen energy. The ISS line is a dead giveaway. It's a well-known legal myth used by people who believe courtroom laws don't apply to them. Spoiler alert,
right here.
they
It's
absolutely
called an
do.
indictment.
And judges shut this down immediately.
And Mr. Lewis has
just
a
like
copy
we're
of
about
it,
to
and he
see.
can show the court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it, and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus, and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claims and not being given the proper opportunity to obtain proper counsel, defective defense.
It's overruled.
Um, okay.
You're running out, aren't you?
No, it's fine.
So here's the thing, Miss Pugh. I appreciate your position, but listen,
Respectfully, Your Honor,
Miss Pugh, don't
with my
speak over me.
incarceration- Respectfully, Your Honor, with my incarceration.
Miss Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen to me. Everything you have there is overruled. And here's one of the reasons why is because you have a lawyer and your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do.
And here it is, the final word. The judge stays composed, but the message is crystal clear. Time is up. 2 weeks. That's it. Hire a legitimate attorney or represent yourself and face the consequences. This isn't just about legal procedure anymore. It's about control, credibility, and how defiance in court can backfire in spectacular fashion. You can go back with the bailiff or the deputy. You already said that, and it's overruled. Go back with the bailiff. Get your own attorney or represent yourself if you don't like it. Cold. Final.
You can go back with the bailiff.
I do not agree or comply to your appointed
Go back.
agents.
You already said that, and that's overruled.
Duty is to the state.
Go back with the bailiff. Get your own attorney or represent yourself if you don't like it.